Now I think we can start. Dear ladies and gentlemen, a very warm welcome to you all to our very first workshop of this annual ACTA conference this year in Athens. Today we will listen to two excellent speakers talking about plain packaging in the industry. At first, we will hear Mrs. Cheng Fong Tang, who will give us a short introduction what plain packaging is or means, and then provides an overview of the actual status of the national legislations in the EU concerning plain packaging. Then Dr. Enrico Bonadio will follow, presenting us the tobacco plain packaging dispute cases involving Australia's law, which are currently pending in front of the World Trade Organization. Afterwards, you will have the chances to ask questions to both speakers. So, as we have quite a program in front of us, I will start with an introduction of Cheng, our first speaker. She is an UK solicitor with around 20 years experience in the IP field, especially in the UK and EU trademark law and practice. She's heading the trademark and the brand department of her law firm Innovate Legal in London. And she's also an active member of the law committee of ACTA, where she was particularly involved in the issues of plain packaging. And now it's time to start. Cheng, please, the floor is yours.
Good afternoon, ladies and gentlemen. I have been asked to discuss the status of the national legislation in relation to plain packaging. However, before we delve into what the EU national legislation has to offer on this issue, let us look into the background and some international treaties on the subject. Plain packaging that we are discussing here relates to the tobacco industry. So the question is it plain packaging? Plain packaging might be better described as standardized packaging. Let me explain why I say that. When we say plain packaging, we might imagine something like this. The one on the right, or perhaps something on the one on the right or the left, where there is a plain background and perhaps just some writing. But these are not what we are referring to. The use of the term plain packaging in the tobacco industry is not plain, as the term suggests. The packaging is fully regulated in relation to the layout, permitted color, design, and shape of the health warning. The packaging looks something like this. Therefore, plain packaging might in certain circles be better described as standardized packaging. Notwithstanding the above, I will continue to use the term plain packaging for the rest of this discussion. Now we know what plain packaging is or is not. Let us move on to see what legislation we are looking at to cause cigarette packaging that once looked like this to now look like this. Firstly, what brought about plain packaging legislation? It is part of the WHO Framework Convention on Tobacco Control, the FCTC, which entered into force in February 2005. This is the WHO's commitment to fighting the global tobacco epidemic. Today, it has 181 parties covering more than 90% of the world's population. Plain packaging fits into the prevention policies and possibly the policy on banning its promotion. The plain packaging legislation we are looking at today is the Tobacco Products Directive. For us lawyers in the IP field, what are the arguments and legislation that can be relied upon to protect IP rights once plain packaging is imposed. Looking at international treaties, the concept of IP rights are entrenched in a number of international treaties, such as the Paris Convention and TRIPS. The technical barrier to trade agreement is also used to argue against plain packaging. Looking firstly to the Paris Convention, Article 7 says, as we can see here, it may be translated to mean that trademark registrations should occur independent of the nature of the goods, whether it may be imported or sold within a member country. The Paris Convention for the Protection of Industrial Property, as we know, is one of the first and arguably the most important of the various treaties protecting IP rights. However, the Paris Convention, for the most part, neither defines the rights nor guarantees any minimum level of protection of these rights. Where there is a lack of provision defining minimum standards of substantive rights and mandating enforcement, TRIPS steps in to address these shortcomings. Article 20 of TRIPS, and we look specifically to the wording unjustifiably encumbered by special requirements, as well as a manner detrimental to the trademark's capability to distinguish. What we're looking at is whether plain packaging amounts to an unjustified encumbrance to the use of the trademark. As IP lawyers, our response is likely to be a resounding yes. Plain packaging is a hindrance to the use of a trademark, and therefore is an encumbrance to the use that a proprietor is entitled to make of its trademark. The position paper of ACTA on plain packaging succinctly argues this point. In short, a trademark must be able to function in its capacity to distinguish, and if there is a hindrance to its use, a trademark will not be able to perform that function. We look also to the technical barrier to trade agreement. The provision requires that member states do not create unnecessary obstacles to trade. So does plain packaging create an unnecessary obstacle? Yes, that's what IP lawyers are likely to say. Plain packaging laws are technical regulations that can be an obstacle to international trade. For example, plain packaging laws could prevent tobacco products lawfully made and packaged in one EU member state from entering any countries where plain packaging requirements were imposed. So, looking at these, we know that, from background, we know that Australia was the first country to implement plain packaging law for tobacco products in 2012. This was with reasons such as health concerns, the heavy burden of disease and death that is attributable to tobacco use or exposure. These concerns are well documented and often debated, but for today's discussions, I will not dwell on them. As expected, there was a legal challenge brought by the tobacco industry, and the case was brought to the World Trade Organization. The WTO decision will be discussed by my colleague Enrico, and we move on to recap here. The WHO framework covers tax, the ban on advertisements, picture warnings, and plain packaging. So what then is the EU's position? The EU has followed the WHO framework with the Tobacco Advertising Directive and now the Tobacco Products Directive, which governs the manufacture, presentation, and sale of tobacco and related products. As you can see, related products seems to be the catch-all phrase and includes e-cigarettes and potentially shisha, which falls under herbal products for smoking. The TPD covers health warnings, such as some of you might have seen them, Your smoking harms your children, and it has a horrible image, usually of a disease, and covers 65% of the front and back of the packaging. Does such legislation stop smoking? Does it prevent the uptake of it? We do not have definitive evidence of this, but what we know is that such legislation leaves very little space for the use of a trademark. Without the ability to use color, design, or even a distinctive font or manner to represent the trademark, how effective then is the legislation in tracing and combating illicit trade, which is one of the points of the TPD? I had the benefit of input this morning by Christopher Morecambe, who's seated there, who mentions some evidence from Australia, saying that despite the legislation in Australia, it has not stopped illicit trade, but contrary to that, it seems to have increased counterfeits due to plain packaging. Next, we look at the UK. The UK was the second country in the world to pass legislation on plain packaging as the standardized packaging of tobacco products regulations, and this came into force on 20th May 2016. Some arguments on its legality. As you can see here, use of trademark as a property right should not be prohibited. To prohibit the use will be to prohibit a trademark from performing its essential function, and plain packaging is equivalent to imposing technical regulations. So we've discussed this based on the international treaties. In order to counter some of these arguments, Rule 13 and 14 of the regulation provides that plain packaging does not form an obstacle to registration. It does not ground for invalidity, and where a trademark has become vulnerable as a result of non-use, plain packaging forms proper reason for non-use. And Rule 14 covers the equivalent issues in relation to design. Let's look now at an example. We see here of a trademark registration covering Class 34. The TPR prevents the use of the trademark for the registered goods, whilst Rule 13 provides that it is possible to obtain a trademark registration and that without use, the registration is still not to be revoked for non-use. We then need to question, what is the value of that trademark registration if it is no longer possible to use it? Therefore, whilst the regulations sought to address some of the issues related to plain packaging, it nevertheless could not prevent a judicial review which was brought to challenge the legality of the regulations. On 19th May 2016, Mr. Justice Green of the Queen's Bench Division of the High Court handed down his judgment in the case of the Crown on application of the British American Tobacco and others against the Secretary of State for Health. This is a case where the world's largest tobacco manufacturers challenged the legality of the UK legislation, the TPR. This keenly awaited judgment was handed down one day before the regulations were to come into force. As we have seen above, the TPR implements the EU Tobacco Products Directive, and it was to substantially limit the ability of tobacco companies to advertise their brands or logos on cigarette packets or cigarettes themselves. There were 15 grounds of challenge, which includes the international law, EU law, and domestic common law, stating that the regulations were unlawful. Perhaps more interestingly, the regulations were also said to be disproportionate in light of data from Australia, which they argued showed that its plain packaging legislation has failed to reduce smoking, bearing in mind that similar measures were adopted in Australia since 2011. In Mr. Justice Green's 1,000-paragraph judgment, he dismissed all the grounds of challenge and held that the regulations are lawful. To those of us interested in procedural matters pertaining to evidence, Mr. Justice Green provided guidance. In fact, he was quite scathing in his criticism of the evidence provided. The four most significant ways in which the evidence submitted was said to have fallen below best practice are: they were not peer-reviewed, the evidence was not benchmarked, the underlying worldwide literature base was largely ignored, and that it was not verifiable. Unsurprisingly, there was an appeal to the Court of Appeal. The Court of Appeal rejected all the tobacco companies' grounds of appeal and confirmed the earlier conclusion of the High Court that the TPR is lawful. So what was appealed? These are very much the same grounds as were considered in the High Court. In the decision, the regulations were said to be not contrary to EU law, in particular the Community Trademark Regulation, as it then was. The owners of the trademarks are not deprived of their rights, but the regulation only sought to control the use of those trademarks. The judge had properly considered the evidence relating to their suitability, necessity, and whether the regulations struck an appropriate balance between the public interest and private property rights. Therefore, the High Court judge was said to have been entitled to find that they were a proportionate means of protecting public health and were therefore a lawful restriction on IP rights. Perhaps the issue that is most debatable is the Court of Appeal's confirmation that a positive right to use a registered trademark did not exist in domestic law, European law, or international law. The court also confirmed that regulations amounted to a control on the use, but did not amount to a deprivation or an expropriation, as some would say. The regulations were a proportionate response to the public health objectives and struck a fair balance between these objectives and the interference with the claimant's rights. We still question these, as mentioned earlier. Is controlling the use of a trademark not depriving the owner of the right in the mark? Is it also a proportionate response? Is depriving or eroding the intellectual property rights a proportionate response? Wouldn't education leading to educated personal choices be a better way? With a decision like this, we can't help but question whether public health objectives are indeed met by such interference of IP rights. Leave was sought to appeal to the Supreme Court, but this was refused in April 2017. Therefore, with that decision, which thoroughly considered the legality of the regulations in the UK and came out firmly in favour of its implementation and legality, we can assume that other countries in the EU will follow suit and implement the directive into national law. However, this is not or not yet the case. I have a list here of countries that has implemented the TPD. I have been corrected slightly this morning that in Finland there is a move towards implementation, but it has not gone to Parliament. And just to point out, in Ireland, legislation requiring standardized plain packaging was adopted in March 2015. All tobacco products manufactured after September 29, 2017 must be in plain packaging. Remaining stock already placed on the market may continue to be sold until September 29, 2018, which is not long now. And next, I have a list of countries which has not yet implemented the TPD. This is not meant to be a list to shame these countries, as they all have their own valid reasons for not doing so. Recently, a German judge, Neugebauer, Bauer, has said that the legislation that they have there in Germany is sufficient for addressing the health concerns, and therefore it is unlikely that Germany is going to proceed anytime soon with its implementation. And in Spain, we've been told that this is moving towards implementation. So now that we've looked at standardized packaging in relation to the tobacco industry, we look now to what happens next. The WHO framework was such when fighting against a certain evil. So what is next? In the UK, we have in recent weeks seen the implementation of the sugar tax. This resulted in an increased cost of drinks with high sugar content. This legislation was meant to target the issue of growing obesity in the population. It starts with increased tax, with arguments based on health considerations. Will this be followed by limitation in advertising, and then followed by plain packaging law? Those from the UK will be familiar with Percy Pig, a type of sweet from Marks and Spencer. This is rumored to be subjected to a potential axe, since the cartoon face of the pig, which is the shape of the sweets, is enticing children to eat them. Will we then see drab green packaging used for sweets or confectionery? To those of us who are concerned and considered plain packaging to be an opening of the floodgates, it is worth looking at these 3 steps in other industries. As for Percy Pig, I hope it does not face the chop. Thank you.
Thank you, Cheng, for your great presentation, which was also very good in time. I'm very impressed. And now it's time to switch over and to hear our second speaker, Dr. Enrico Bonadio, presenting us the tobacco plain packaging dispute cases on Australia's adopted public healthcare measures, which are pending before the WTO. Enrico is a solicitor qualified to practice in England, Wales, and Italy, and he teaches IP lectures at the University of London and also at other universities, for example, France and Finland, and also 2 IP Master of Law programs offered by WIPO. He's a special expert on plain packaging, and for his paper, Plain Packaging of Tobacco Products under European Intellectual Property Law, he received the ACTA Award for the best paper on trademark law in 2013. And among others, he also just recently co-edited the book Beyond Plain Packaging, the New Intellectual Property of Health, together with Alberto Alemano. Enrico, the floor is yours.
Thanks, Mary-Christine, for the introduction. So in this talk, I will focus mainly on the Australian case, the first case, and beyond. So I will also mention other cases regarding plain packaging and in general packaging, tobacco packaging related measures. So as Cheng already said, this is anything but plain, right? Plain packaging, the term plain packaging is not really accurate. It's standardized packaging. There is nothing plain there. No, it's full of information there. Here, the government basically has taken over the marketing experts, and the government is dictating what is going to be on the pack. It's not anymore the marketing expert that decides here. It's the government. It's kind of social marketing, I would say. So the Australian move, the plain packaging in Australia entered into force in December 2012. It was implemented in Australia because of these facts, basically. Smoking kills 15,000 Australians a year and costs the community about 31.5 billion Australian dollars annually. The aim of this measure was to get down the smoking rate to 10%. That was the original aim. As we know, I mean, we still are waiting for the report by the WTO panel. The report should be out in a few weeks or months, very soon. But according to informal leaks, it seems that Australia has won the case. But these leaks have not been confirmed officially, so there are lots of speculation here around. But of course, big tobacco majors have not denied such leaks. So we will see in a few weeks, in a few months, what the panel will decide. The funny thing here is that in this litigation, it's the first time developing countries complain about IP violation. Usually, developing countries have always been accused of stealing IP, of infringing IP. In this case, Indonesia, Cuba, Dominican Republic, Honduras, all these countries have challenged the Australian measure. So it's the first time developing countries jump to the defense of IP. It's quite curious. It's a lengthy progress, I would say. Many years since the dispute was started, also because of the high number of complainants, the number of third parties which want to have a say, the number of the TRIPS and Paris Convention provisions that are involved, relevance of other treaties here, right? Cheng has already mentioned the WHO, the Framework Convention on Tobacco Control, the Doha Declaration, another WTO document. The report will likely be very long. The report of the panel will likely be hundreds and hundreds of pages, then to be translated also in French and Spanish, so lots of work. Two main issues in this dispute, a legal issue and a more scientific issue. Let's now focus first on the legal issues, let's say. The most important point, which was also mentioned by Cheng before, is the nature of trademark rights. So the panel will need to determine whether the TRIPS agreement offers trademark owners positive or negative rights. This is the most crucial point. If the panel confirms that TRIPS confers just negative right to exclude, probably plain packaging will be okay. If, of course, on the contrary, the panel says that there is also an implied positive right to use stemming from Article 20 and other articles of the TRIPS provisions, plain packaging might be in trouble, let's say, right? But a few years ago, the WTO panel, in another dispute concerning geographical indications and trademarks, has already said that TRIPS does not provide for the grant of positive rights. So there is a big precedent here. In another dispute concerning other issues. So this might be quite a determinant, I would say. Just negative rights to prevent certain infringement acts. There is no such positive right, said the panel in that case, exactly to allow governments to regulate the use of intellectual property, the trademarks, for public policy purposes. If we think that the TRIPS agreement confers a positive right to use, that in general trademark registrations confer positive right to use that cannot be touched by governments, well, this interpretation would probably call into question the compatibility with the TRIPS of other tobacco control measures, such as advertising restrictions, no? The restrictions on the use of brands in advertising, TV, radio, Formula One races, and so on and so forth. Well, then other judges, let's say, have already said that trademark rights are negative. For example, the Court of Justice of the European Union in the first tobacco directive case, no, back 15, 16 years ago, no, in this opinion by Advocate General Gelhaud, the Advocate General was clear, no, trademark rights just provide the negative rights. The essential substance of a trademark right does not consist in an entitlement as against the authorities to use a trademark unimpeded by provisions of public law. Very clear. In This other case, this was a case, the British case that Chang also mentioned, no? The challenge to the British plain standardized packaging measure. Again, there, Justice Green, the judge, said, TRIPS just gives trademark owners negative rights. There is no right to use the mark to harm public health. That's quite strong finding by the judge. And the use of trademarks can be curtailed by governments on public health grounds. So governments, said the judge here, have a broad power to adopt health legislations, even when these legislations have a strong impact on the manufacturers of tobacco products, because they cause the health problem. What the Secretary of State said in the dispute was quite strong. This is an exceptional case, because there is no other widely used consumer product in the world that kills half of its long-term users prematurely. The judge was quite impressed, I think, by these assertions, I would say. Of course, the opponents of plain packaging strongly say that this measure, as Chang already mentioned, jeopardizes the distinctive function of trademarks. Of course, consumers are confused. They cannot distinguish between brands. They cannot make an educated purchase choice, and this is not possible. It's a violation of the sense of trademarks, right? In another case, in the case I mentioned before, another WTO case of a few years ago, the WTO panel said, every trademark owner has a legitimate interest in using its own trademark in connection with the relevant goods and services. This is an interest, right? Or a legitimate interest of trademark owners. However, also, I go back again to this decision of the High Court in London on the British standardized packaging challenge. Standardized packaging does not entail a total loss of distinctiveness. There is a loss of distinctiveness, of course, there is. But it's not total. Word marks, not logos, word track marks in a standardized form can still be displayed and can still play a limited distinctive function. This was also stressed by the judge to exclude, to deny that there was an expropriation of a property right. And according to the judge here, the word trademark, even in standardized font, is capable of distinguishing tobacco products in a retail environment. In a retail environment, especially, I would add, when the government in question, such as Australia, such as the UK, has adopted another tobacco control measure, which is the display ban at the resale point. When consumers go and buy the cigarettes in UK, Australia, not in all countries, but they don't see actually the packs, right? It's shut. What they see is just a list of brands in standardized form, and if they already don't know what they buy, because most of them they know, they are fidelized customers, if their purchase decision is made by looking at such list. They don't look at the pack anymore. So there are different interests in using the trademarks, of course. Different kind of interest in using the trademarks. The interest in distinguishing the product, of course, so is a legitimate interest that must be protected against whoever confuses, whoever infringes. But there is another interest, which is the interest of tobacco brands to use the brand to promote the products. Interest in distinguishing, interest in promoting. Very often the two functions overlap, right? On the pack especially. So governments, with this measure, Australia, UK, Ireland, blah, blah, aim at neutralizing the promotional effects of tobacco brands in social settings, after the customer has purchased the pack, at the restaurants, at the pubs, at the bars, at the cafes, where the packs might play a kind of mobile advertising function. silent salesman or the silent billboard, I would say. So governments, they target the pack because they want to curb, they want to reduce, to neutralize such promotional effect of brands. The problem is that the two functions, distinctive and promotional functions, here overlap. So if you want to curb, if you want to limit the promotional function of tobacco brands, you also have to attack a bit the distinctive function. You can't really attack the promotional function without also touching the distinctive function, I would say. Well, the Americans think differently, of course. In America, it's totally different. In America, there was a proposal entabled by the Food and Drug Administration, right, the regulator in America, it was not plain packaging day, it was 50% of the pack now to be reserved to health warnings and images. So, well, such proposal was basically ditched by the court here on free speech rights. You may know that in America, of course, commercial free speech is quite strongly protected under the First Amendment to the Constitution, right? So very strongly protected, more than it is protected in Europe and in Australia, for example. So there the court said, no way, you can't really pass this measure, exactly because these images, these warnings would have the aim to shock instead of informing consumers. So totally different approach from the Europeans. The scientific issue, this was I have expanded on the legal issues. Now what about the scientific issue, which is really important in the WTO challenge for Australia? One of the important provisions that the panel will expand on is Article 8 of TRIPS agreement, which basically allows states to adopt measures which are necessary to protect public health. A necessity test, right? A necessity test. So the issue here is plain packaging necessary? Does plain packaging satisfy this necessity test? This necessity test consists of two sub-elements. A suitability test, which means basically, is it really effective? Is this measure effective? Well, the opponents of plain packaging might say, there is a lack of evidence, there is no scientific evidence, really certain that confirms that. If there are other measures also that could be adopted instead of plain packaging, such as educational campaigns, just 50% of health warning instead of 100%, advertising restrictions that are already in place in many countries of the world, higher taxes, which have an impact on the price, ban on consumption on public spaces, and so on. So the opponents of plain packaging say, no, okay, the plain packaging does not satisfy the necessity test because less IP restrictive measures could be adopted that obtain the same result, right? Consumption decrease. Well, the issue of evidence, again, is important and is quite subjective, I would say, because Cheng, for example, before mentioned the fact that according to certain statistical data, consumption of tobacco in Australia has not decreased. Well, I have other data and other scientists have other data that seems to confirm that there has been a decrease in consumption, right? The problem here for the proponents of this measure is to demonstrate that it has been just plain packaging that has contributed to such a decrease. There might be concurring elements, concurring measures that have contributed, right, to such a decrease, such as, in this case, higher taxes, higher prices for the final consumer. So it's really difficult it might be difficult for the proponents of plain packaging for Australia to convince the panel here that, yes, plain packaging has been the measure that has contributed to the decrease of consumption. Well, the Court of Justice, in another dispute, the dispute that regarded the second tobacco directive, the tobacco directive of 2014, so a few years ago. You may remember that such directive has mandated, harmonized the following measure. 65% of the pack should be devoted to, reserved to health warnings, blah. Well, the Court of Justice very clearly said that such a measure is not disproportionate, does not go beyond the limits of what is appropriate and necessary to obtain such a result, protection of health. The Advocate General in this case very clearly said, the less extravagant the packaging of a product is, the less consumers, and above all young consumers, will be tempted to purchase it. So, according to the Advocate General, this measure seems to meet, to satisfy, to obtain, to meet the target. What about other fields? Cheng already mentioned, other things. There might be a domino effect after tobacco in other sectors. What about alcohol? May we think about bottles like this? No, there might be a domino effect. What about, alcohol? And it's not really so rare, because we are already witnessing measures imposed by governments that mandate manufacturers of alcohol to reserve, let's say, 10, 20% of the label to health warnings. So the space available for brands might shrink, right, on the label. What about junk food? Can you imagine a Big Mac like this in the future? Want to provoke, it's a joke, it's a joke. But it might not be quite a joke, because we can see already that such health warnings are already appearing. Governments are already, for example, in Chile and in other countries, they are already mandating food manufacturers to display to such warnings. I don't know, in the future, for food that are very rich in salt and trans fat, ingredients that are not really healthy, I would say. I want to provoke even more. What about gambling? Gambling is addictive, right? It creates addiction. Can we think in the future maybe a government imposing restrictions on betting companies to use brands? A Las Vegas casino without lights? I don't know, just provoking. Okay, I just want to conclude my presentation with a more philosophical and sociological note. These measures, plain packaging in particular, are considered to be measures to be categorized as an anti-state measure, right? The government wants us not to consume a certain product, right? This has been considered as a kind of libertarian paternalism. The government here is not obliging us, is not preventing us from buying such product. We are free, it's a legal product. We are free to buy it and to consume it. But here the state is, by restricting the use of brands on the pack, is basically nudging the consumer. It's trying to push the consumer towards an healthy path. It's libertarian paternalism, which is not an oxymoron. It's libertarian, it's paternalism because the state is trying to convince us not to buy the product. But it's libertarian because it leaves the final decision with us. So it's not an oxymoron. And such theory was developed by American scholars and Cassius Staines and the recent Nobel Prize Richard Taylor, that have theorized this nudge theory. And plain packaging can be categorized in this group of measures. So my last slide is dedicated to the city of Athens, which is hosting us today. So thank you so much for your attention.
Thank you, Enrico, for this great presentation. It was a pleasure to listen to you. And I've got a question for you. I'm just reading this actual report here, the actual bulletin, June 2018, and there's something interesting in there. And you just said that there is no positive right for a trademark owner to use their trademark. And let's assume I'm a lawyer representing a tobacco company, and my client, with my help, has put a lot of effort and money in making their trademarks well-known and even famous. And right now I feel that in my body that it can't be right, that these rights should suddenly stop because we can't use the trademarks any longer, and the status of the famous trademarks will fall down. And I just read out of this ACTA report, which is part of the conclusions of the meeting of the European trademark judges, where Mrs. Grabrupa also participated. Maybe she can tell us later on something to that. And there is written that the Article 17, Section 2 of the EU Charter states that intellectual property shall be protected in the context of Article 7, Section 1, which provides that everyone has the right to use his or her lawfully acquired possessions within the parameters of Article 52.
It was the last body of law was that Article 7.
Article 7, yeah, the EU Charter.
Okay, 17.
There is mentioned, yeah.
Okay, I understand that, of course, this is the main argument brought by tobacco companies, right? I have paid trademark registration fees to the state because the trademark office is an emanation of the state, and now the state is telling me you can't use it, right? So I understand their concerns, I'd say. From a pure legal perspective, the TRIPS agreement is quite clear. Article 16 speaks about a negative right, right? The owner of the registration has the right to prevent others from exploiting. That's it, right? There is no express mention of any positive right. Of course, the opponents of plain packaging say, yes, but we need to adopt a teleological interpretation of the TRIPS agreement, right? A purposive interpretation of the TRIPS agreement. Trademarks are there because they need to be used, because they create, the negative right create the space within which the trademark owner is interested and must use the trademark. This is the argument. But my counter-argument, strictly legal counter-argument, by looking at the TRIPS agreement is the word right in the TRIPS agreement is mentioned 131 times. Positive right. 131, excluding the title, trade rate agreements of intellectual property rights. If the Uruguayan round negotiators had intended to give a positive right to trademark owners, they would have repeated 132 times instead of 131, right? That's a purely legal, of course, argument. And then, again, as I said in the presentation, if we interpret trademark rights in the TRIPS agreement as a positive right, really we could call into questions all advertising restrictions, all those restrictions to use the brand on papers, on TV, not to advertise, to promote. We could recall in question all these measures. Oh, this is the legal argument, I would say. From a more economic perspective, it's true. I mean, they have spent lots of money in making the brand known, and now they are strongly limited in the use. But I also think and believe that the way we perceive this product has changed through the years. Tobacco, consumption of tobacco. The way we perceive and also the consequence of tobacco consumption now are really quite clearer than, let's say, 20, 30, 40 years ago. As the Secretary of State in the British dispute said, this is a very particular product, totally different from the other. And in my opinion, and in the opinion also of the others, trademark legislation should not give immunity to trademark owners from governmental action. But of course, I still understand tobacco companies' concerns. Many questions.
Okay, there are a lot of questions. Mrs. Krapoka, do you want to say something? Because I think you were persistent.
Exactly to this point, we were discussing the issue under the view of constitutional rights. And let's focus on the European law. And we are the European Trademark Judges Circle. So we say the CTEU affirmed that brands are property. And property is a constitutional right. And you may limit the property under social aspects, but you can't deny it. And this is just the question, how far the border, or as the advocate Cocotte said in her opinion, you have to focus on the border. Yeah. What is the core point of property in your brand and not? So we see it more in the sense of property. And the CTU said in several decisions, brands are property, constitutional guaranteed property.
But again, there is no, I mean, the British judge, the European judge, all the judges have said that there is no positive right. If there is no positive right, there cannot be infringement of the use.
No, but there is a different opinion on this. This is the core point, you see. Is it negative or is it positive? And I will say it has to be defined as positive because the CTEU always focused on the point it's a constitutional right of property. So how
so
can
it's
you
written in the
deny-
Constitution that it's a positive right?
Yeah.
No.
Yeah, if it's
You interpret.
If property is
But
a constitutional
Article 16
right.
of the TRIPS agreement says negative rights.
So we can discuss in the next years, okay, on this point. I just want to focus that there is another opinion on another view.
Absolutely.
Yeah. We should not only focus on TRIPS, we have to consider the TRIPS under our constitutional law. And in Europe, it is as it is. It's property. And it's the same like your house or your car or whatever. You know.
I'll just jump in.
You may use your car 1 hour a week. Is this...
I can't go 200 miles per hour.
Okay.
I'll just jump in at this
am
point,
limited,
if I
not-
may. I think I agree with your point of view in that if you have a right, then it is not just the property right to use the mark, but also, in a sense, to create the sense of what is around the branding of that mark, which is so important to so many brand owners, not just using a particular name, but to be able to promote a sense of maybe loyalty to a particular brand. And if that is taken away, then the value of the trademark is substantially depreciated. But having said that, if we go to what the Court of Appeal and also the High Court judge said, it is not the taking away, well, it is a taking away, but you can still use your brand in the sense that you can stop others from using your mark. No doubt you can't use it yourself. So it's not quite what we want to hear, but that's what's been said.
Okay, Max, yes, please.
Okay, thank you very much, Enrico. It was very, very stimulating. I think you need to know that in the article written by Enrico in the new intellectual property of health, you are arguing on a literal basis. And you are saying that if you don't do that, you might end up with a different solution. So I would urge you to be a little bit careful when you are saying that the literal solution is a legal solution, because I think law is the art of argumentation. And the question is the context, and that is also important. So just for your information, all of you here sitting in the audience. Thank you, Enrico.
Okay. Thanks.
Christopher, please.
Yes, I think one thing is clear, what has been said, is that what has happened in relation to tobacco products has set an extremely dangerous precedent. Now, can I just take up a few points on TRIPS? One point, I think it was Enrico who mentioned Article 8.1, which does allow provisions justified on grounds of health. But unless I'm much mistaken, that article, or a later one, also says that that does not detract from the other provisions of TRIPS. So that is perhaps an answer to that point. Secondly, I think if you look at Article 20 of TRIPS, you can even see within that reference to distinguishing of goods, capable of distinguishing goods, that it's implicit in that is a right to use the trademark for that purpose. And my final point is looking at Article 17 of the EU Charter of Fundamental Rights, which incidentally I hope that Britain will keep post-Brexit following the amendment made in the House of Lords, we shall see. But in Article 17, it specifically mentions, as has been said, intellectual property. And an elementary proposition, and here the first questioner, I think, touched on the same point, property is not only in the registered mark, property is in the goodwill acquired with the public by using the mark, and one is entitled to preserve that. And at the end of the day, the right of property, generally speaking, carries with it a right to use it.
Thank you. Any further questions? No? Okay. I think then our workshop. Oh, yes, Mrs. Grabrugger?
I just have one question to you. Why do you think, privately, why does, let's say, Germany is not more active in this way?
Yeah, I've seen also
it's a big
there are
country in the
advertising
EU.
billboards of cigarettes in Germany. So also years ago I could see advertising tobacco in the street in Germany. So I don't know. I'm not aware of the German debate about this, but
The debate is starting. The debate is starting. Very, very.
Yeah, but they have not taken such a drastic, such a strong measure. I mean, also to answer to the other questions, I take this opportunity also to answer to the other questions, comments, let's say. It's true, Article 8, Paragraph 1 also says that such measures should comply with the other provisions of the TRIPS agreement. But again, if we interpret the rights as negative rights, there is no violation, right? Because the negative right is still kept. So that's the logical antecedent, right? If we interpret the rights as negative, there is no violation, right? It's quite clear under Article 8.1. And you talk about goodwill. They have an interest, no? Tobacco companies have an interest in maintaining their goodwill. The same goodwill that consumes their products and kills half of their customer base. We never, ever have to forget this. This is another kind of product. And we might need to start thinking in a more specific way when it comes to this specific. I mean, in the field of patents already, we have different kind of rules, no, for some kind of inventions, more socially sensitive, I would say. I think we should start doing the same in the field of trademarks. I know that I'm, saying something that is anathema to many in this room, but I think, yes, it may set a dangerous precedent. You, Marco, you think it's dangerous. In my opinion, it's not. It will set a precedent, it's true. Of course, I personally don't agree on plain packaging on a nice bottle of Chianti. I come from Tuscany, I love Chianti, so I will want to have my red wine, my bistecca alla Fiorentina with the red wine, with the Chianti. I don't want plain packaging for the wine, of course, but a label, 10-20%, reminding consumers, yes. Of course, but tobacco is even more harmful than the wine, than yes, absolutely.
I read with interest the article by Judge Neugebauer, and those of you who may have been at INTA earlier this year may have read in that bulletin as well, which was brought to our attention by Christopher Morecambe, that he did mention that the regulations that yes, we've got that there, that are already in existence, such as the increase in tax, the restriction in advertising, is already taking effect and being effective in curbing smoking. And he then went on to say that to step into plain packaging is not something that he sees Germany doing anytime soon. So whilst I'm no expert in German law and the German position, it was very interesting to see his comments on paper to basically say that there are other means of achieving this health objective and not just by plain packaging, which impinges on IP rights.
Can I just add
A very quick comment. Yes, because we are running out of time.
Sorry, just to give more food for thought, I just want to bring the example of cannabis, cannabis consumption. It's legal in many countries now, in America and Colorado, soon in Canada. It's a legislative option to minimize the risk coming from the consumption of such substance. Well, in countries that have legalized cannabis consumption, the government might also be interested in preventing cannabis growers and distributors from using the brand on the packs in order to discourage the consumption. I think it's a quite a reasonable aim, right? The product is legal, but you cannot really promote it by putting fancy logos on the pack. Do we want to give cannabis growers the right to prevent governments from doing that by relying on the positive right to use the trademark? My opinion, no.
But cannabis is illegal in the most countries.
Yeah, but in several countries, such as Colorado, California, there are restrictions, severe restrictions on the use of brands on the pack. Do we want to give them the right, the possibility to invoke the right, the positive right to use them, to impede, to prevent public law provisions aimed at discouraging the consumption? We could discuss for hours and hours.
Okay, I have to make a cut. It was very good to hear so many answers and questions and comments, and this has been quite emotional. And I thank you both very much for the great presentations. And I also thank you all for your interest and time in this workshop. And I wish you a very interesting and fruitful and very special ACTA conference this year in Athens. Thank you very much.